Hello everyone. Welcome to today's Owen Mitchell webinar on navigating legal changes and what charities need to do now to protect their organisations, their employees, and most importantly, the vital services you provide to a wide range of service users and their families. We're delighted to have so many of you with us representing charities across many sectors, including education and youth, cancer and asbestos related diseases, mental health, brain injury, bereavement and hospice care, road safety, wildlife and the environment, and a broad spectrum of healthcare causes. It's encouraging to see such a diverse group come together, especially as many of you face similar challenges in today's difficult economic climate. I'm very pleased to introduce four of our legal experts, Stephanie, Georgie, Danielle and Joanne, who will share practical insights on key developments affecting the charity sector. Throughout the webinar, please feel free to submit your questions for any of our speakers. We'll aim to address as many as possible during the session. If you'd like a personal response, please include your name and email address and we'll follow up with you directly after the event. A feedback form will also be published during the course of the webinar, and we would appreciate it if you could fill this in, as this will help us plan future events and topics you want to hear about specific to the charity sector. Our first topic is legacy income and inheritance disputes, and I'm delighted to introduce you to our colleague Stephanie Kerr, who is a leading expert on advising on disputes relating to wills, trusts and estates, including Inheritance Act claims. Stephanie.
Thanks, Lynn. Cheers. So I'm going to be talking about inheritance disputes and in particular the importance of the stewardship of the donor journey and the information that you collect at various touch points with the people that you rely on for your income. There's a brief slide about the people in our team, which is next, and you'll get a copy of this so that you can see all of our faces again later on. And then moving on to the agenda for the topics that I'm going to be discussing. I appreciate the subject of this webinar is navigating legal change. We've got two potentially significant changes to the legislative framework that will affect charities in the next couple of months. Those being the new IHT provisions. Obviously, the current position with IHT and the discounts that can be applied for charitable gifts are of massive benefit to charities. Those are really important conversations to have. They aren't necessarily the types of conversations that I would have as a dispute solicitor, but we do have a team at Owen Mitchell that can help with that. And if you wanted to get in touch at the end of the webinar, then please do so, because our legacy partnership team will be able to help you out with those sorts of issues. So the types of disputes that can arise, this is the second set of changes really. The Wills Act currently is from 1837, so it isn't exactly breaking news, it's quite old legislation. The difference that is potentially going to make is not yet known, because we don't actually know what the final terms of those changes are going to be until it actually gets passed in Parliament. But I see that there's potential for charities to be affected when they're responding to Inheritance Act claims. The reason for that is, from my perspective, the current definition of the net estate, which is what everyone is arguing about in an Inheritance Act claim, that doesn't include pension provision. But the IHT changes are potentially going to bring the value of a pension into the pot for the purposes of inheritance tax. And there is currently, based on the way that the procedure is planned to work, there is currently a risk that the estate will bear the tax and then have to recover that from the pension beneficiaries. So charities might find that their legacy is delayed because the personal representatives of the estate have to pursue the pension administrators for the tax that's been paid, and they in turn might have to pursue the beneficiaries of that pension to eventually reimburse the estate and then give the payment to the beneficiaries under the terms of the will. As I say, it's all up in the air at the moment, but that is one potential possibility that I don't think has been properly thought through from the perspective of the Inheritance Act, and there might be the need for the Inheritance Act to be changed so that the wording of what constitutes the net estate catches the relevant provisions. We've then got validity challenges, which obviously are very expensive, and we do find that people are becoming more litigious, both in validity challenges and Inheritance Act claims. That may be because people are waiting for wealth to be passed through generations and they have an expectation that they are going to receive something. So the changes that are planned, again, with the Wills Act, which may or may not be passed next year, there are lots of changes. So keep your eye on your legacy offering. Make sure that you're up to date with what needs to be done. And it may be that there are changes about presumptions for undue influence, witnessing of wills, which might now be able to happen in a different way, potentially electronically. And from my perspective as a litigator, one of the most exciting things is the potential for us to have dispensing powers. This isn't covered as a slide on the webinar, but dispensing powers are currently in place in a number of Commonwealth countries. And that is when the court can look at a document which isn't a valid will, and the court can say, yes, I am going to say that this is a valid will. So some examples from Commonwealth countries, so Australia, Canada, New Zealand, courts have decided that an unsent text message would constitute a valid will, a video recording, audio recordings, so lots of different ways where the court will look at a document, whether it's electronic or written, and will say, I believe that the testator intended this to be their will. So for charities, there might be a text message that says, I want all of my estate to go to charity and I don't want it to go to my family. So there is a potential for a charity to make an application if the changes happen in the legislation to maximise that income and say, we have a document here which isn't a valid will, but we think it is evidence of that testator's intention. So just moving on to the stewardship of the donor journey. This is really about collecting data about the people who your charity comes in contact with and how that can affect what I do in the context of an estate dispute. I know that Joanne is going to be speaking later about the data laws, so she might have something relevant to say. She might disagree with me on some of these things. But the relevant things really are looking at the testator's life, their interests, hobbies, how they may be affected by a particular charity. So, has a charity cared for a testator's loved one or cared for them? We also, I've had cases where, a person has said, this will should not be upheld because the testator didn't have a particular link to that particular charity. And it's been helpful to be able to say, well, actually, we have records where this particular testator has donated belongings on a regular basis with a gift aid record to a particular charity. Now, on the flip side of that, I personally donate to a charity shop regularly when I am getting rid of various things that the children leave hanging around. And the reason that I donate to that particular charity is not because of an affiliation with the charity's purpose, but simply because it's the only one locally that's open on a Sunday. So from my perspective, there is a great way to say there is a link, but there is also an argument to say, is it a genuine link or is it just convenient? That also applies to lottery tickets. Again, is it a genuine link to that particular charity, or is it just that the testator enjoyed having a bit of a flutter and thought this is a decent prize and I'll sign up to that lottery? So the last point really is the most important from my perspective, because a will file prepared by a solicitor or a professional will drafter is a really crucial piece of evidence. So if your donor has made a will as part of the charity's legacy campaign, or included a charitable gift in a previous will, or has any charitable historic giving record, then that is a really interesting and important way for us to work with charities to uphold wills that give them gifts. So I'm going to talk now about charity names and tips to avoid ambiguity and failed gifts. If we can have the next slide, please, Lynn. Thanks. So this is possibly very obvious, but using the correct charity name, using the correct address, using the correct charity number. I recently looked at a will where it had been referred to me because there were 2 errors in the charity name or the charity number. And when I actually looked further at the will, I found that it wasn't just 2 errors, it was a 3rd error because there was another error that hadn't been picked up in a different charity name. So always direct your testators or your donors to the correct information. If you have a legacy pack, then make sure that it's really clear what they need to do to make sure that there is no ambiguity. And does your website give instructions on how to leave a legacy? If there's a similar named charity where you might potentially have some crossover or scope for dispute, does your website differentiate you from that particular charity? Again, in terms of the practicalities, think about a clause to redirect the gift to a similar charity if your charity is no longer around. So, for instance, if your charity is for the research into cure for the common cold, but the common cold is cured, then your charity no longer has that particular purpose. So, does it need to be redirected to a different purpose or a different charity? I'm going to move on to a case that dealt with the charity name, which is the British Racing Drivers case. So in this case, the testator had been a professional racing driver, a long-standing member of the Racing Drivers Club, and the gift in his will left the gift to the British Racing Drivers Club Benevolent Fund, which didn't actually exist as a charity in its own name. So the court, I should say, when we talk about taking court proceedings, the court will always try to do its very best to work with what the testator would have wanted, and will try to use a common sense approach to make sure that charities maximise that legacy income. So in this case, the British Racing Drivers Club Motorsports Charity, which was administered by the British Racing Drivers Club, was appointed to be the recipient of that gift. There was also a second gift, a cancer research fund, which didn't match any existing charity at that time. And all charities with similar names had ceased to exist by the date of death. So again, the court found that there was a general charitable intention, and Cancer Research UK and the World Cancer Research Fund agreed to take half of the shares with the court's blessing. So that's the key, really. The court is blessing the decision of the various parties to distribute in that particular way. So there is also an often unknown process called the Royal Sign Manual Procedure, which is where the signature of the King, delegating that authority to the Attorney General, will identify charities if the identity is unclear in a will. And again, the real important factors are: which charities did the testator have links with? Did the testator speak about any particular charity to their family and friends? So it's a very subjective sort of review of all of that information. Then on the next slide, we've got an example of how that might be applied in practice. So this example is a person who has drafted their own will. So the crucial evidence of the will file isn't there, it doesn't exist. They've literally done it themselves. And the will has gifts of the residue in equal shares to Paul O'Grady, the TV presenter, for charitable purposes connected with rescue dogs and the Hospital for Sick Animals. So the personal representatives can apply to the Commission for a CPRA scheme in relation to the gifts. The Commission looked at the Paul O'Grady gift and said that needs to go to the Battersea Dogs and Cats Home because of the association with that charity between the TV presenter and his TV show. And then the Hospital for Sick Animals, testator lived near to the Queen Mother Hospital for Animals. So again, that was an obvious redefinition of what that was actually intended as. So it's a really interesting, sometimes long-winded process, but again, a real common sense approach adopted by the courts and the Charity Commission in these cases a lot of the time. So then ambiguity and errors. There have been quite a few cases where the courts had to look at ambiguity because something just obviously isn't clear. Now, in this particular case, there were 8 gifts of money made to 8 different entities. 3 of those were individual people, family members of the testator. 5 of those gifts were to charities. 2 of the charity gifts were to the same charity but for different purposes in different locations. And I've put the wording in red and blue there, which was questioned. So the residue was going to such of the beneficiaries named in clauses 4.1 to 4.8 in accordance with the provisions relating to each gift. Now, the claimant, who was one of the family members, wanted to cut out the charity's share of residue, and that was because the solicitor's will file had a note in it that said that the residue was to be shared between those people named in such and such a clause. And the claimant said, well, the charities aren't people, so the people are at 4.1 to 4.3 of the will. And in effect, he's arguing that the testator was charitable, but not so charitable as to want to leave a gift of residue to the charities. There was also the second part, which is in blue, which is what does that wording mean in accordance with provisions relating to each gift? Does it mean in accordance with the amount as a proportion of the residue? Does it mean in accordance with the purpose relating to those charitable legacies? Or does it mean something else? So because it was ambiguous, the court looked at the will file, which again is of crucial importance, and decided what does that actually mean. Now, there were competing documents, so there was a file note, there were handwritten amendments on a draft of the will, and there was eventually the executed will, and those 3 documents did not tally with each other. But the court took a common sense approach again and said beneficiaries to receive the residue are all of those beneficiaries, including the charities. So the reference to those people does not mean individual people, but it means those beneficiaries. And the distribution of those gifts was on a basis of how much they had each received as a monetary legacy, and that was then reflected in the percentage share of the residuary estate. So I mentioned earlier how conversations with testators are really important, and if you've got a legacy process in place, then the firm dealing with that for you should be having these important conversations. So the testator might want to prepare a letter of wishes to accompany the will, or a witness statement to explain why they're excluding a particular family member, or have made a will in a certain way, not leaving somebody all of their estate. And the Supreme Court said, actually, we are going to look for a link between the deceased and the charity to help defend claims, or to at least assess those claims. So that was in Illit and Mitson. So I often will look at a letter of wishes that's been drafted by our private client team and say, actually, I'd like a bit more information about how often this person has had contact with the charity, what the sort of quality of that contact has been. Has it been as a service user? Has it been as a relatively modest donor? Just so that we can sort of put as much information in there as possible. And then the point about testators having conversations not only with the will drafter, but with their own families. This really does depend on the personalities, because if you've got a difficult relationship with families, they might not want to actually say to the family, look, I'm leaving, half of my estate to charity, and I'm going to reduce the amount that you get. But if there is a reasoning for it, such as IHT savings, discussing that with the family can help. And in many cases, if you do the maths based on the IHT savings, making a bigger gift to a charity can reduce the tax that's paid to HMRC, and it can actually, in some circumstances, increase what the individual beneficiaries receive. So those conversations are really important, not only from the perspective of the reputation of the charity and the perception of family members, but from a litigation perspective, I find those discussions, having been noted, as being really important evidence for me to work with to help charities to defend these claims. And then the last slide is completely contradicts everything that I've just said in this talk, but it is an interesting case. So in the case of the Vegetarian Society in Scott, there was a gentleman who was neither vegan nor vegetarian. He had no previous links to the Vegetarian Society. And whilst the joint experts concluded that he was most likely suffering from schizophrenia at the time, that did not affect his capacity to make a will. So the will was valid. And the judge in that case just said that the plain fact is that he didn't feel the natural bond of love and affection with his blood family, and he just decided to leave his estate somewhere else. So he picked a charity that he had no link with and made his will to benefit that charity, completely contradicting everything I've said so far. Thanks, Lynn.
That's great. Thanks, Steph, for a very insightful and clear presentation on what is obviously a very complicated topic at times. I've just got a question for you, Steph, especially for us non-lawyers. Obviously, you mentioned about the Wills Act may or may not come into force, changes next year. Why is that a 50-50? Why is it sort of not definite that it could come in or might not
So
come in?
it's got to go through the parliamentary process. And so the Law Commission has done a consultation. It's done a few consultations actually in the past about potential changes, but none of them have ever got to the point of being a bill to go before Parliament. So, as can sometimes be the case, Parliament's priorities can change over the course of the parliamentary year. They might run out of time to deal with it. It doesn't have to just go through the House of Commons, it has to go through the House of Lords. And so there is quite a long-winded process. And over that course of time, it might be that the proposed initial wording of the bill changes significantly based on input from practitioners or input from the general public, or it might be that they just want to make some tweaks because it doesn't tie in with other legislative sort of strategies that they've got. So
Okay.
it's a little bit like the IHT changes. We know what might happen,
Mm.
but it's not definite until it's actually passed.
Yeah, so you can prepare to a certain extent for any changes, but until it's literally stamped
Yeah,
and put into force.
yeah.
Okay, that's great. Thanks a lot, Steph. Really appreciate the presentation.
Thank you.
Our next topic is intellectual property, and I'm delighted to introduce our colleague, Georgie Collins, who is a leading intellectual property lawyer helping individuals and organisations devise IP strategies to secure and protect their IP rights. And over to you now, Georgie. Thank you.
Well, good afternoon, everybody. Hopefully you can hear me. Sorry, I've had a few technical issues with the Wi-Fi here. Next slide, please. Lisette, thank you. So I'm going to help you navigate some key issues around IP and why it's important, why it matters, and why it's relevant to you. I'm going to take you on a whistle-stop tour of what you can protect, talk about some common myths and misconceptions that I hear every day and try and dispel those, and some pitfalls to avoid. Next slide, please. So IP is important and particularly relevant to you because much of IP is about brand, and brand helps build trust. And for charities, that trusted brand is critical. It's part of how you communicate your purpose, how you engage with your supporters. And a recognisable and protected brand reassures your supporters, your donors, your beneficiaries, the public, in the reassurance of what you're doing and how they are going to engage with you and, you know, ultimately fundraise. It also helps you stand out, particularly in the current economic climate where charities are finding it harder to fundraise and attract donations. IP is also an asset, often forgotten, albeit it's intangible, but like any asset, it will have a value and it can provide a source of income, for example, through licensing or collaborating, which can actually help support your broader activities. Next slide, please. So I've detailed here the various different IP rights. And actually what I should start off by saying first is, what is IP? So intellectual property is a term that's used to describe a collection of different intangible assets, so such as names, goodwill, rights arising from the creation and invention of new products and ideas. They're different legal rights which protect the various different intellectual property rights. Some of them have to be registered to be effective, and some of them arise automatically on creation. And I've listed them here and will run through them in detail in a sec. So the registered rights are trademarks, designs, and patents. And then rights arising without registration. So you can have unregistered trademark rights, which protect your reputation and goodwill, commonly referred to as rights in passing off. Copyright and moral rights, unregistered design rights, database rights, an often forgotten right, and rights in confidential information and trade secrets. I'm going to run through the most relevant rights to charities in terms of how they may manifest themselves in your organisation and your activities. Next slide, please. So for most charities, trademarks are going to be at the top of the list in terms of what you should look to be protecting. And particularly given the reliance on donations from the public, it's really important to have a strong trademark that helps you build that trust, but also provides you with a mechanism and a stronger enforcement mechanism than typically relying on unregistered rights to enforce your brand should it be misused. Typically, the most common trademarks would be your name of your charity, your logo, perhaps a slogan, although there are some slightly more quirky marks that you can register as a trademark. So, for example, sounds. The Dulux dog barking is a registered trademark, and colours. So, for example, the Tiffany blue. As I said before, so having a registered trademark will allow you to prevent others from using the same or similar marks. Very important to carry out clearance searches when you're looking to adopt, for example, a new name or a logo. That's both to ensure you can actually use your chosen name, but also that it's going to be available to register. Trademarks are a really valuable right. They have the potential to last indefinitely, providing you use them as they're registered and you renew them every 10 years. Design rights, and there's both a combination of registered and unregistered design rights. Registered designs have a 25-year lifespan, unregistered last 3 years, and they're often used in combination with trademarks. But they're protected in a different way and enforced in a different way. They will protect the appearance of a product or an article, so they can cover things like shapes, patterns, colours, ornamentation. In relation to what you might be doing, they could protect your logo, they could protect certain types of merchandising, fundraising items, badges, pins, and again, used in combination with trademarks, they can kind of help build a real layer of protection in relation to both how you appearing from a stylized perspective, such as the logo, but also products that you may have that helped promote you and fundraise. Next slide, please. Patents. Patents are less common in the charity sphere compared to, say, trademarks or design rights and copyright. But for charities involved, for example, in medical research or other advances, they may be very relevant indeed, particularly where they're going to relate to new inventions and processing. In addition to that, from a licensing perspective, patents could be very beneficial and lucrative in terms of providing a source of income. Copyright, you'll all have copyright. Copyright protected works, for example, they will cover articles, research, marketing materials such as your brochures, reports, fundraising materials, your website, blog posts, sound recordings or films which might be used as part of a fundraising campaign. Copyright arises automatically, so it's not a right that needs to be registered. And typically depends on some of the types of works, has a very long lifespan in terms of from the life of the who created it plus 70 years. In terms of ownership, and this is often a bit of a thorny issue, and spins into the pitfalls I'll talk about. If the work of a charity, if a copyright work is created by an employee, then copyright in that work will belong to the charity. But you need to be really careful if you are commissioning works from a third party, i.e., not an employee. You will not own the copyright unless you have an agreement to the contrary. And it's a real misconception, actually, not just of charities, but businesses and individuals, that they think that if they have commissioned somebody and paid for a work, that they're going to own the copyright in it, and that just isn't the case. One little addition to that is many of you will probably use the C in the circle, the copyright symbol. No legal requirement to do that. It doesn't automatically prove you have ownership of copyright, but it's recommended because what that does is that shows to other people, first of all, you know a little bit about your copyright protection and have thought about your IP, but it makes them think twice about copying your work. And it also increases the likelihood that in the event somebody does copy your work, you may be able to obtain damages from them by showing that you put them on notice by virtue of using that C in the circle. Database rights. These are a lesser known IP rights, and whilst copyright could protect the selection and arrangement of material in a database, database right is a completely separate right which covers the material within the database itself and how it's organised. You have to have made an investment in obtaining the data, presenting it, and verifying the contents of it in order to attract protection. You don't need to register it. It lasts 15 years from creation. But if you think about certain databases, as you update it, you create a whole new period of protection. So it's going to manifest itself most commonly in things like contact lists, mailing lists, lists of your donors, contributors. It could subsist in your website, document management system. So it's quite all-encompassing. And again, a really valuable right when you understand that you've got it and how you look after it. Next slide, please. I thought I'd run through some common myths and misconceptions that I come across daily, and not just related to charities. I tinkered with some of them to make it specific to charities. But often one of the comments I get is, we're just a charity, we're not a big brand, we don't need to register a trademark. It's strongly advisable that you do. The follow-up comment to that is, yeah, we're not a big brand, we're not a Coca-Cola. Why would somebody copy us? Well, unfortunately, the impersonation and the nature of people who will often try and, impersonate a charity with a view to gaining funds, unfortunately, is on the increase. And having a registered trademark, particularly in the virtual world, from the purposes of taking down nefarious operators who might be encroaching on your brand, can be really powerful rather than relying on your unregistered trademark rights, those rights in passing off I mentioned. I registered the company name, so I own the brand. No, they're two completely different things. The same goes for a domain name. It's a brand of sorts, but it's not a trademark. It's just one of the things that makes up a collective of a brand. People say, oh, I've got copyright right. You told me copyright arises automatically. I own that in my logo, so I don't need to register the trademark. Well, the trademark is protecting the logo in a different way to copyright. And actually layering these different IP rights helps you build a really defensible brand and a portfolio of IP. We don't need to carry out a trademark search. We've been using our name for years. You may well have been, and you might not have popped up on someone's radar. But if you want to be protecting your trademark, we strongly advise carrying out clearance searches so that you are free to use and somebody isn't going to come and tap you on the shoulder. And actually that you can register it without opposition. And then the other one is we register a trademark so no one else can use it. To a degree, it depends what you've registered your trademark for. So trademarks are categorised according to 45 different classes of goods and services. So you won't get a trademark for everything. Well, unlikely to. There are some brands that have done that, but you will typically fall within a number of those classes. And if someone else could use the same mark into something completely in relation to something completely different. So, for example, there are a number of trademarks that exist side by side but doing completely different things. An example would be, say, Polo. So Polo for the mints and Polo for the Volkswagen car. Same trademark, but in relation to completely different things. Final slide, please. So common pitfalls that we see, I mentioned this when talking about trademarks, is failing to carry out a brand clearance search prior to use and registration. It really gives you the headwind of, are there going to be difficulties ahead? And also, to the extent that you want to secure registered trademark protection, scours the registers and helps you navigate if there might be potential conflicts that you need to have regard to before filing an application and dance around. Having no trademark registration at all makes enforcement much more difficult where there's an encroachment on your brand, whether that's your name or your logo. Cataloguing your rights. So often with charities, we see that, they've operated for a very long time. The same people are not running the charity as might have been the case years ago. And it's not really understood what IP, particularly that unregistered IP, the charity has, particularly, say, copyright or rights in confidential information. And understanding what that IP is and who created it. Was it created by employees? Were third-party contractors engaged? Is really important in understanding sort of what that legacy is and actually showing the value of that IP as your asset. The biggie is often around IP ownership, and particularly when working with third parties who are not your employees, and particularly in the charity sphere where they're seen as, not in a business, not necessarily looking to make money, and collaborating with others, and it's all very friendly to start off with. Thought often isn't given to what is being created, who is going to own that, and what would it look like if one person wanted to use it over the other. So being clear and having a form of agreement in who's going to own it, how it might be used, is really critical to avoid issues later down the line. The same applies to collaborations and sharing ownership. So often charities themselves might collaborate with another charity that's in a similar area, particularly if it's, say, in relation to, R&D, other advances, but understanding when they're coming together, both in terms of their organisations and their people, whether they're, employees or they're independent contractors, who's going to own those materials and what are they going to be allowed to do with them? And then lastly is monitoring your rights. So you go to the trouble of protecting them, registering them where you can, is understanding how they're being used in the outside world, and maybe being misused. So there are things that you can get to monitor your rights, particularly trademarks. So for example, you can have alerts if someone might file a trademark that's considered similar or identical to yours, so you can take quick action. Same with company names, same with domain names. So they're really great resources in terms of you understanding kind of like what the health of your IP is, because if you're not getting any results from those monitoring services, there's little encroachment potentially on your IP. But if there is an issue, then you get notified where there may be a problem, which you can look into. Back over to you, Lynn.
That's great. Thanks very much, Georgie, for explaining all things IP. And just in the Q&A during Georgie's talk, we published a link to our brand accelerator service designed to help you protect and develop your intellectual property, which we hope you'll find of interest. And please do click on the link for further information. Georgie, I've got one question for you. You did already mention earlier on about third-party organisations and how they would potentially use a charity's logo and copyright. But obviously, all of our charities have a fantastic array of volunteers who support their chosen charities. So, what's the advice for charities to ensure that their copyright if a volunteer, how the charity ensures the copyright they own, the IP, that a volunteer might have a little bit of a fiddle with or create or extend the actual sort of copyright of their logo?
Yeah, it's really tricky, particularly with volunteers, because they're volunteers and they're doing it out the goodness of their heart. And you've hit on a real issue, because the charity doesn't want to appear to be mercenary about the situation and taking advantage of someone's good heart. But you don't have to have a 25-page agreement. You can have a light touch, which needs a bit of hand-holding and explaining as a charity why we're doing this, because we've got to protect the charity and its interest. But say for example, photographs are often a bit of a vexed issue, in that you have volunteers who will go along, take perhaps photographs of a fundraising event, but they will own the copyright in that photograph because they took it. But the charity might want to use those, might want to use it on its website to showcase what a great fundraiser it was. But later down the line, someone pops their hand up and says, no, that's my photograph, you can't use it. And it's been on the website, it's been in printed materials. What then? And theoretically, the person who took the photograph would have the right to say, you've got to stop using that, unless the charity could say, by virtue of what they discussed, but of course it's not on paper, they'd have an implied license to use it. But that becomes a bit messy.
Okay. Very complicated indeed.
Tricky, yes.
That's great. Thanks a lot for that really interesting presentation, Georgie. Our next topic covers employment law changes, which obviously affects every organisation. And I'm delighted to introduce our colleague, Danielle Symington, who's a specialist expert in employment law. Over to you, Danielle.
Thanks very much, Lynn. Yes, I've been tasked with talking about the Employment Rights Bill, which I am sure 99% of you will be aware of. It is the biggest set of legislative change that we are expecting within employment law for the recent years, and I'm here to talk about just 3 elements for you today, because it is a vast amount of legislation that's going to be seeing a lot of changes over a course of 2 years. So the points that I will be covering with you today are day 1, unfair dismissal rights, changes on how you can use 0-hour contracts, and also third-party harassment. If I could have the next slide, please, Lisa. So as part of my preparation for the talk today, I looked at what pressures charities are under generally, and it's key that there's clearly a difficult time for a lot of charities out there with a number of factors that you're facing. And unfortunately, I do envisage that the Employment Right Bill will increase the pressures that are placed upon charities because of the changes that are going to be happening in the near future. If we could have the next slide, Lisa. So what is the Employment Right Bill? It's been around for a number of years now, and we are in fact still waiting for the parliamentary process to actually complete on this bill. It is envisaged, and this hasn't been changed yet, that it will actually receive royal assent this month, although it has just recently gone back to the House of Commons for further discussion and amendment potentially. The Employment Right Bill itself is actually just like a framework or a skeleton of the changes that the government are seeking to put in place within employment law. And they have published a roadmap of how they envisage this bill will take place over the course of the next 2 years. Part of that is ensuring that there's going to be a consultation period for those elements. Now, those consultation periods were actually meant to start in summer, early autumn time, but they actually only started on the 23rd of October. So they're already a little bit behind their time frame, really, in implementing these changes. But those consultations are ongoing. They are open until the 18th of December and the 15th of January for 4 key topics. Now, they're in relation to trade union measures, rights for pregnant workers, and bereavement leave. Now, anybody can actually contribute towards these consultations, and it's open for feedback from employers as well. And it's actually a really relevant process for people to get involved in to ensure that input is received of what the regulations for each change are actually going to look like in the future. How to do that will be, there's information within the roadmap that the government have included, and we've included the link within this slide so you can look at that in further detail of how to get involved in those consultation processes should you feel like it's relevant to your organisation. As I've mentioned, it's the biggest overhaul in employment law that we've seen in a long time. It did start out as a very simple document, but it's grown exponentially to over 330 pages. But we have to admit, still have to take into consideration that's not actually including the detail of how these regulations will actually work in practice. That's what the consultation is going to assist with in due course. So of course, this is really going to impact your HR teams in terms of being able to implement what these changes are and what you need to be doing legally to ensure that you're not going to fall foul of these changes. Could we have the next slide, Lisa? So this is just an overview of what's actually happened in terms of the process of the bill so far. You can see it's been debated in both House of Commons, House of Lords. Most recently, as I mentioned, it's gone back to the House of Commons following the House of Lords on the 28th of October, so only very recently, insisting on several further amendments that have already previously been rejected by the House of Commons. This hasn't changed the fact that royal assent is still expected this month, and that's what we're working towards. But we will see if there is going to be any pushback of that. So what would happen after the bill is actually passed? So if it receives royal assent, it's going to become law. And if we could have the next slide on that, please, Lisa. This just shows a general timeline of what this roadmap that the government has produced is indicated in terms of when these changes are likely to take place. So as I mentioned, it's going to be over a 2-year period, but there will be some immediate changes after the bill receives royal assent in relation to mainly trade union provisions. But then we've got further changes in April 2026, October 2026, and then final changes within 2027. Now, I'm not going to go through those in detail because there's so many different topics that the bill actually covers, but the key ones for what I'm discussing today are, in fact, for October, there's going to be, if these still stay as planned, potentially extending the time limit of bringing a tribunal claim against an employer from 3 months to 6 months, and also the including liability for third-party harassment upon employers. Then in 2027, the key changes that we're discussing today are day one unfair dismissal rights and also guaranteed hours for 0-hour or low-hour workers. If you could do the next slide, Lisa, thank you. So as I mentioned, the bill covers a wide range of employment law issues that you can see detailed on that slide. I won't go through them in detail, but if you do want further information, then we can discuss. I'm just conscious that we're very limited on time today in terms of what we can actually cover. But if we could go to the next slide, Lisa, and start by looking in more detail on day one, unfair dismissal rights. So typically, claims for unfair dismissal actually cost UK employers millions each year in terms of dealing with claims that are brought and also dealing with settlements to try and resolve those more swiftly than going through a full tribunal process. However, what the bill is trying to put into play is removing that 2-year qualification period that an individual must reach prior to being able to bring a claim for unfair dismissal unless they have an automatically unfair reason, so something like discrimination or whistleblowing, because that doesn't need the 2-year continuous service element. So if this occurs, and it is going to occur, it's going to really significantly change the landscape of risk associated with tribunal claims for employers. In addition to this, the bill is also bringing in an increased time limit for bringing claims from 3 months to 6 months. Now, the reasoning behind that is that the powers that be have determined that that would assist in trying to resolve matters via settlement rather than it proceeding to tribunal within that short 3-month period. However, it's believed within the industry that it's just going to give more opportunity for individuals to bring a claim in a tribunal because they've got that 6-month period to do so, rather than potentially being time barred from doing so, from missing that 3-month element. Additionally, and it only actually happened earlier this week, the ACAS early conciliation process, which is a process that an individual has to go through prior to being able to bring a tribunal claim in an employment tribunal, actually is going to extend their time frame for dealing with that process from the current 6-week period to a 12-week period. Now, the reason for this is because there's such a backlog within the early conciliation process that they're just not getting through claims, and nobody's been able to actually really benefit from that service. So again, that's going to assist in trying to avoid tribunal claims, but it will potentially impact the ability to be able to bring claims within that period. So what's going to be changing? So the bill is going to remove that 2-year qualification period. Currently, as drafted, and what's wanted by the House of Commons, is that they will be able to have an unfair dismissal right from day 1 of employment. There will likely be a statutory probationary period put into place. It's envisaged it'll be a 9-month period. And within that period, there will be a simplified process to be able to terminate an employment contract. We don't quite know what that simplified process is as yet. That will be dealt with in the consultation periods that will be upcoming in the coming years, but it will be deemed to be a light touch process. It's envisaged that it will still include the fact that there will need to be a meeting, they potentially will be allowed to be accompanied to that meeting, and written outcome be provided. Now, however, as I mentioned earlier, the House of Lords on the 28th have rejected this day 1 unfair dismissal right. They don't agree in terms of allowing this right to be made within employment law. They believe a 6-month qualification period would be fairer across the board to individuals and organisations. And one of the main reasons for that is that they're concerned that having a 1-day right will deter employers in employing individuals potentially who are younger, have less experience, because there's potentially higher risk that they're not going to be able to perform the role that they're employed to do. It's envisaged that the House of Commons are going to continue to reject this because they really are pushing for a day 1 right for unfair dismissal. It was part of their manifesto, and it's unlikely that they're going to agree to the 6-month point. So we continue in this stage of back and forth between the House of Commons and the House of Lords to determine what the ultimate position will be. So what would dismissal during a probation look like? It will be for the normal reasons, fair reasons for dismissal. So they include conduct, capability, illegality, and some other substantial reason. Redundancy is excluded from that, but it's not exempt from the day one protection right. So even if an individual is made redundant from within that initial period, that 9-month period potentially, then they're still protected from day one rights. But what it means within the current drafting of the legislation is that you can follow a simplified process for redundancy. You would have to follow a full redundancy process if that was the reason for the dismissal. So how is this going to impact upon employers? Is it clear that it's going to potentially increase the risk of tribunal claims? Because if it's either going to be 1 day, 6 months, or a day in between those two proposed periods, it's going to give the opportunity for individuals to bring claims of unfair dismissal against their employer rather than this current position of the 2-year period. That in turn is going to increase cost for charities in having to either pay out in terms of settlements or just in terms of cost of having to deal with the management of a claim internally and externally if a claim is going through the tribunal process. What can we do to try and support this at this stage? Because steps can be taken at this time. We're going to need to look at employers putting in more robust onboarding performance management processes. Documentation is always key, and employment lawyers will always say, please document everything in terms of the processes that you take. You also need to make sure that your management team are fully aware of what these changes are and how to handle such processes. They need to be seen to be acting proactively to any issues that arise during this probationary period, and that they know how to handle dismissal procedures fairly. Unfair dismissal has 2 points in terms of being able to prove it successfully within an employment tribunal. The first is the fact that there's a fair reason, so whether it's conduct, capability, etc., but also that there's a fair process that's being followed. So it is really key, especially if it's going to be an earlier right to bring a claim, that the individuals within your organisation have the capability and knowledge to be able to handle these situations within a fair process. So action steps for what you could take, I would advise looking at and reviewing probationary policies or put in place a probation policy if you don't have one already. Within that, ensure that you're demonstrating dismissal decisions that are reasonable and will be compliant with the new regulations when they come into force. Consider introduction of a structured probation review process within the organisation. If you're going to be working on a 9-month probationary period, then look at potentially reviewing 2 or 3 times within that process. Make sure that your recruitment and onboarding procedures are as tight as possible. If we can ensure that you're hiring the correct individual for the role in hand, hopefully that would then reduce the risk of potentially having to terminate contracts within that probationary period. And again, key is really ensuring that you're training your management team and ensuring that they know how to comply with such processes and that they can document the process that they take. So you've got evidence if it did go through a tribunal of what steps were taken and why. If I could have the next slide, please, Lisa. Thank you. So the next area of the bill that I want to discuss is changes to 0-hour or low-hour contracts. So I found this statistic that said that over 2 million workers in the UK are on a 0-hour contract, and many charities rely heavily on this type of arrangement within their organisation. So this change from the bill is probably one of the most complex and one of the largest impactful changes that's going to occur following the bill becoming law. It is so complex and difficult to navigate, and that's even before we've got to the consultation point. So it is a real key issue that we're hopeful for further clarification on in due course. If I could have the next slide. So in more detail, what's going to happen? So the current position for 0-hour contracts is that they allow flexibility within an organisation, but they're often criticised because it's a one-sided flexibility. where the worker, the individual, bears the brunt of the unpredictable hours. Now, for some individuals, that works fine, but for others, it doesn't. And in practice, it's been hugely beneficial to a number of organisations, but arguably they've been misused by a small proportion of the industries out there at the detriment of the individual. Therefore, the changes that are sought under the Employment Right Bill is to provide a greater security and predictability for the workers who are employed under these types of contracts. So what's changing? In terms of what's going to be changing, the workers on 0 or low hour contracts will have the right to request a guaranteed hours contract after 12 continuous weeks of service. This is known as the reference period. Therefore, what that will allow for is that if they work consistent hours within that period, then they're allowed to or have the right to be offered a guaranteed hours contract to reflect that regular working pattern. The reference period is currently set within the bill as a 12-week period, but that could be subject to change. And it is currently the position that employers must review the hours worked by individuals employed under these contracts to calculate whether or not there is a guaranteed offer that needs to be provided to them. It includes any employee or worker on 0 hour, low hour contracts, and there must be an offer to that individual if the above points have been met. So, as I mentioned at the onset, this is a really complex area of the Employment Right Bill. And there is, again, a number of back and forth between the House of Commons and the House of Lords. Originally, the position was that the employer had to guarantee hours and make a guaranteed hours offer to that individual after every reference period. But the House of Lords sought to amend that and made it a request that, made it that it would have to be requested by the individual. That was rejected. And then on the 28th of October again, the House of Lords have made another amendment to propose that the option for workers to opt out of receiving a guaranteed hours contract offer. So what would that mean for you if, as an organisation? It would mean that after the end of each reference period, you would need to send the worker a written notice explaining their right to receive guaranteed hours contract and giving them the option to decline or accept. If after that initial offer, they could confirm to you that they don't want to receive any further offers of guaranteed hours, but they could opt out of that again in the future. There are other changes in relation to 0 hour contracts that are also going to be coming into force. So it affects not only workers and employees, but it will affect agency workers. You must ensure that you give reasonable notice of shifts, and compensation will be payable for short notice of cancellations. There will also be additional protection for employees that employers cannot penalise workers for accepting or rejecting guaranteed hours, and you cannot reduce pay or benefits when offering out a guaranteed hours as an alternative. In addition, there will be anti-avoidance measures to prevent employers from manipulating hours to avoid triggering the duty to offer a guaranteed contract hours. Or what these will look like in practice, we're yet to know. So again, how does that impact employers? So you're more likely going to need a more robust system of being able to track the hours worked by the individuals under these contracts to ensure that you're not going to miss those reference periods if it's triggered by that continuous working pattern. You must be prepared to be able to promptly offer a guaranteed hours contract to them, and unfortunately, again, it potentially risks the increase of tribunal claims if offers are not made or there are breaches in terms of that you're cancelling shifts at short notice, etc., which potentially could eat meet reputational risk also. So what can you do to prevent, or what can you do to start to plan for this change? So currently we could look at auditing your current hours, current contracts for 0 hours, low hour workers. How many do you have? Are there any individuals that are already working a regular pattern over a prolonged period of time? Getting that information now is going to assist in being able to determine whether or not that would impact in the future. Updating your scheduling systems to ensure that you can manage compliance with notice and cancellation rules. And again, management training is really going to be key to being sure that they can put this into practice and communicate to workers what the rights are. Next slide, please, Lisa. The final topic that I want to just briefly give an overview on is third-party harassment. So currently you're not liable for harassment by third parties only unless you fail to act after repeated incidents. Of course, in October 2024, there was a change for sexual harassment in the workplace, making it a preventative duty that was placed upon employers. It's going to be similar for third-party harassment prevention also. The change is likely to come into play in October 2026, and the employee will have a statutory duty to take all reasonable steps to prevent harassment by third parties. Now, this doesn't just apply to sexual harassment, it actually applies to all protected characteristics. So the other characteristics under the Equality Act, so race, religion, disability, sexual orientation, etc. Now, it could happen in a number of ways, and it's really going to be very dependent upon how your organisation works and how your employees undertake the duties that they're employed to do. So, for example, if you're holding a public awareness event for your charity and you have a stall in the public area, but your volunteers, workers on that stall receive homophobic remarks, that would be potentially a third-party harassment situation that you would have needed to look to prevent prior to it occurring. So it's going to implicate employers vastly, and especially within the charity section, you'll have a number of individuals that work in a public-facing role, so it is quite a high-risk area. And additionally, you potentially have staff that lone work, again, increasing the risk of the risk to be able to be subjected to third-party harassment. So what steps can you look to take at this time? We need to be looking already, and even though it potentially is a year away, but start to looking at strengthening your anti-harassment policies and procedures to include details about third-party incidences as well. Train staff and volunteers on how to respond and report any concerns about third-party harassment. Conduct risk assessments within the workplace to ensure that you've got an understanding of the roles that do have that public interaction. Look at putting up clear signage within public spaces within the organisations to inform that you will not tolerate harassment by volunteers, or by service users, etc. And making sure that your policies and procedures are going to be up to date to be able to deal with those changes that are upcoming. And then final slide, please. So as I've mentioned, the Employment Rights Bill is continually changing, and it is going to continue to change over the next coming years while we finalise the details. So it would help you if you could keep in touch with us, and there's a number of ways that you can do that. We have monthly employment newsletters, we produce blogs about changes that have occurred, and we also have a podcast as well. You can sign up to those to get that information direct to your email, and we also have a back to basic training session package as well that can assist with providing training to your management team, and it's a learn at your own pace process for video training that's applied to different scenarios. So for example, we have that on sexual harassment training, how to handle grievances, how to handle performance management process, etc. If there's any particular area of the Employment Right Bill that you're most worried about because you think it's going to impact your organisation, greatly, then please do reach out and we'll see how we can support and provide further information on that. Thank you, Lynn. That's all from me.
That's great. Thanks, Danielle. A question has come in from Ella, and I think she asked it when you were talking about the changes to 0 hours. And she said, will this affect bank workers?
In bank workers, in what regard? It would depend upon the terms of the contract, but it is going to affect employees and workers. So technically, yes, it would, but it's going to come down to the terms of their contract of how they're employed.
Okay, that's great. Thanks very much. There's lots to think about in terms of the employment in the new update. So I do encourage everybody to follow our blogs and podcasts, which come out regularly on the changes. Thanks very much, Danielle.
Thank you.
And we'll just now move on to our final topic, which is all about UK data protection laws, which introduces the new requirements and changes to the existing UK data protection laws. And I'm delighted to introduce our leading expert on this, Joanne Bone, who advises organisations across all sectors on their data protection and privacy. Over to you, Joanne. Thanks.
Thanks, Lynn. Good afternoon, everyone. We don't have a lot of time left, so it's going to be quite a quick canter through, so hopefully it won't be too breakneck speed. So on the first slide, you'll see that the Data Use and Access Act was passed in June of this year, and it's the biggest shake-up of data protection laws since GDPR. And there's quite a lot of changes that have been put through with the Act, and it's quite broad in terms of the types of change that has happened. It has been bubbling away for quite a while, and the original data protection reform was proposed under Liz Truss's government. The idea behind it is to help smaller organisations deal with what was seen as a piece of legislation that was very red tape heavy, also to promote innovation and easing administrative burdens, as I say, in relation to the less risky types of personal data. There's a quick timeline there. I'm going to have a look at the end of the presentation in terms of a practical timeline as to what you can do and when, but you'll see that it is being brought in piecemeal. So there's only certain bits that are in now. The intention was that it would all be in by the 6-month mark, so the 19th of December, but it's now looking that some things will move, including something that's very important for charities, which is the ability to use the charitable soft opt-in for fundraising. And that's actually the first thing that I'm going to have a look at because it's the biggest change, I think, for charities. So moving on to the next slide. What this is it's levelling the playing field for charities with commercial organisations. And it relates to direct marketing. And you might think, well, we don't do direct marketing. But direct marketing from a data protection point of view includes fundraising and the promotion of the aims of a charity. And so to carry out any form of direct marketing, be it commercial or be it sort of fundraising and the raising of the promoting of aims, there has to be a lawful basis to do it. And the two that are relevant are consent and potentially a form of consent, which is the soft opt-in. Anyone that's tried to get GDPR level consent, UK GDPR level consent, you'll know it's not that easy. It has to be very granular, it has to be very clear, there has to be affirmative action, and it has to be renewed. So it's not that easy to get. And certainly commercial organisations aren't always that keen on going down the route of opt-in consent. What a lot of commercial organisations rely on is what's known as the soft opt-in, which is essentially opt-out. And it can be used, as I say, without getting GDPR level consent, where, for example, the commercial organisation has either sold goods or services to someone, or they've had their contact details as part of a sale process, or they've shown sufficient interest to sort of get across the threshold. They are marketing from the same organisation and they are marketing similar things, an ability to opt out of receiving the marketing was received when the information was collected, and also there's an unsubscribe in every subsequent communication. We're talking about electronic marketing here in terms of the soft opt-in, because that has additional requirements to normal sort of snail mail type requirements. So I should have mentioned at the outset, it is relating to electronic marketing. So it does help commercial organisations. It was available to charities in relation to potentially where goods and services have been provided, but was not available where essentially the charity wanted to fundraise, wanted to contact people in relation to the things that they were doing in terms of what their aims are moving forward, etc. So it was generally regarded that charities were a bit on the back foot and it wasn't really a level playing field with commercial organisations. So that is changing in the Data Use and Access Act. So moving on to the next slide, charities can use essentially an opt-out, not an opt-in approach to cover fundraising and promotion of aims going forward once it's brought in. From the timeline you might have spotted, it is going to be due in January 2026 is what the information we currently have, although obviously that might change again because it's not written in stone. If you want to use the soft opt-in in terms of fundraising, etc., what has to happen is that essentially there has to have been some initial contact with the charity in terms of they've obtained the individual's details as a result of somebody expressing an interest in what the charity does, or potentially previously making a donation. It has to be the same, not a group organisation relying on it. It has to be for the charitable purposes in terms of, for example, as I say, fundraising. And like the commercial soft opt-in, there has to be an ability to opt out when details are collected, and also an ongoing unsubscribe. So as I say, the idea is that it levels the playing field with commercial organisations, and it makes it easier for charities to continue to contact people where people have chosen not to give a hard consent in terms of an opt-in consent, which, as I say, it is quite hard to get that level of consent, and it's also quite hard to get people to actually tick the box and give that consent. So it should be a very positive thing for charities. I think one thing that's worth bearing in mind is that it can't be used retrospectively, so you can't backdate it. And there is also a little bit of a kicker in that it relates to electronic marketing via email and SMS, not by telephone. So it doesn't allow you to market in that way by telephone. And also, because it's subject to the Privacy and Electronic Communications regulations, which sits on top of UK GDPR, all electronic marketing does, the fines for breach of the Privacy and Electronic Communications regulations are going to be brought into line with GDPR level fines. So big numbers in terms of, in the UK, maximum fine of 17.5 million or 4% of worldwide turnover. So big numbers, but it is very useful, I think, and certainly is something that charities had been lobbying for some time. So moving on to the next slide, AI is obviously a hot topic. AI is everywhere in terms of, can it be used to help organisations reduce costs, to make organisations more efficient, etc. And certainly charities are no different in relation to it. It's probably worth making the point that there is no AI Act in the UK at the moment. It is proposed that there will be a bill in the spring, but as yet we haven't seen it. We don't know what it's going to contain. One of the big things that is relevant from AI in relation to AI is automated decision making, because obviously the point of AI is that some of it is making a decision via the AI rather than human involvement, and the cost savings that enables you to make. So that brings into focus automated decision making, and can you use personal data to do that automated decision making? And certainly we know from talking to clients, they're very keen to use it for things like recruitment, so that at the first stage of a recruitment process, there might be an awful lot of CVs that have to be filtered, and so using AI makes life a lot easier. The issue with it is that it was very heavily regulated prior to the Data Use and Access Act. And if there was automated decision making where there was no meaningful human involvement, and there were significant effects, so there would be significant effects or legal effects relating to recruitment, then it could only happen if one of three things was there. So it was necessary for the contract, and as I say, necessary, not convenient, authorised by law, or it's based on the explicit consent of the individual concerned. So they're quite hard hoops to jump through, and there has been quite a lot of criticism in relation to it. So the Data Use and Access Act, part of it, as I say, has been used to pave the way for more use of AI, and also to make these things so they can be picked up in the AI Bill and AI Act next year. So moving on to the next slide, the Data Use and Access Act makes it clear. It relaxes the position in relation to automated decision making, and it allows automated decision making to be used where there's a sort of legal ramification, or that there's a serious impact arising from the decision, and it relaxes the position in terms of you can generally do it provided there are safeguards. So it sort of reverses the situation. So under the old Act, you probably couldn't do it apart from three situations. Now you can do it, but there are safeguards that have to be put in place. And the sort of safeguards that have to be put in place are things like individuals have to have the right to understand about the decision. So you've got to be transparent, which means you've got to deal with it in your privacy notice, which certainly explaining the decision making and the AI and how it works in a privacy notice is going to be no mean feat. I can definitely say that. They have to have the ability to make representations, and they have to have the ability to actually request human involvement, because they may not think it fair in terms of the decision that's being made automatically about them. The other thing to bear in mind is it cannot be used for special category data. So special category data are things like health data, ethnicity, trade union membership, things like that. There's a list in Article 9, and you cannot use automated decision making in relation to that. There will be some codes of practice coming out of the ICO, and certainly they've already started to generate material relating to the use of AI, and it is very useful. So I think it is positive in that it will allow organisations to take advantage of AI and to use it to make decisions involving personal data. But there are controls around it which you do need to be wary of. And as I say, if you're going to use it for special category data, then you can't use it unless the three things that were there before in terms of necessary for contract, etc., are in place. So that takes me to the changes to special category data. In terms of moving on to the next slide, as I say, special category data is set out in Article 9 of UK GDPR, and there's a list, and it's a finite list. What is going to happen under the Data Use and Access Act is that it's not changed now, but it is possible, it will be changed going forward, in that the Secretary of State will have the ability to issue a statutory instrument to expand the list. So you do need to be aware of additional things that can be added to special category data. And the reason you need to keep up with what that might be is that for anybody that's familiar with the distinction between ordinary personal data and special category data, is that essentially special category data is subject to more controls and has to be handled essentially with kid gloves. One thing to bear in mind is that essentially the current Article 9 list can't be narrowed, it can only be expanded. Moving on to the next slide, recognise legitimate interests. One of the things that I've mentioned a few times is that in order to be able to use personal data, you do have to have a lawful basis to use it. And one of them, which is regarded as the most flexible, is legitimate interest. But if you're going to use legitimate interest, you essentially have to carry out a legitimate interest assessment, which where you balance the rights and freedoms of the individuals versus how you want to use it for your internal purposes, and which way does the sort of balancing test go. It's not always easy to do, and a lot of people are a little bit nervous about whether or not they've actually gone the right way with the decision making. Essentially, what the Data Use and Access Act will do is there will be, we don't yet know definitely the full details of it, but there will be some recognised legitimate interest where you don't need to carry out the balancing test, and you'll see that those are on the slide in terms of things like safeguarding, disclosure to public bodies, and there'll also be some legitimate interest examples that may be okay. Sort of, it's possibly that they can be a legitimate interest without the balancing test, and there'll be things like direct marketing, intergroup transfers, and as I say, there's definitely more information to be provided around those in terms of in the guidance and also via statutory instruments. It's just worth bearing in mind, because if you do use legitimate interest, the idea is that certainly for the ones that are a bit like no-brainers in terms of things that you should be able to use personal data for, it takes away the uncertainty. Moving on very quickly, DSARs. I'm assuming that you probably get a lot of DSARs, as do most organisations. We've certainly seen a growth in DSARs over the last couple of years. They've grown a lot, and certainly organisations do struggle to deal with them in a way that means it's manageable in terms of the timescales and also the investment in terms of man hours, person hours, and also the cost in potentially of taking advice. So the Data Use and Access Act does bring in some changes, which is hopefully, I mean, essentially they codify ICO guidance, but they will make things a little bit easier in that if you have clarified a request, then the clock stops, and that is codified. Also, it is put into statute that you only have to carry out a reasonable and proportionate search. I think this is really helpful in terms of people's expectations as to what you will do. Now you can turn around and say it's in statute that it only has to be a reasonable and proportionate search. And also there is a requirement that rather than immediately running to the ICO if the data subject does not get what they want, is that they have to go through the complaints process of the organisation that they've put the data subject access request into. And again, I think a lot of people do immediately run to the ICO because they think they can force things from the organisation by threatening to complain to the ICO. So they're all very helpful. I think moving on to the next slide, you'll see that there's also been some changes in ICO guidance, which again are there to make it a little bit more manageable, I think, in relation to handling the growth of DSARs. They've been clearer now about when you can seek clarification. Certainly we see a rise in DSARs which just say, please can I have all my personal data, which if somebody has been involved as a volunteer or as an employee for a long period of time, that may be very challenging to deal with that. So when you can seek clarification, it's quite useful that the ICO has been clearer about when that can happen. So you can ask for clarification where you want to understand the scope of the DSAR, and also where you hold a large volume of personal data. So if somebody's only worked for you for 3 weeks, you're not going to hold an awful lot of personal data. So the ICO would think it unreasonable to clarify the request because you don't really need to. As I've just said, the clock stops while you're waiting for the response. Helpfully, the ICO guidance makes it clear that if you don't get a response, in terms of if you asked for clarification and you get no response, then you can treat that part of the DSAR as being concluded if you don't hear within a month of making the request for clarification. So that's really helpful. It does, however, require you to keep records in terms of clarification communications because the ICO might ask for them. So I think it is quite helpful in terms of the amendments that are being made to DSARs. I'm certainly not pretending that they're going to be easy to deal with, but certainly it gives you a little bit more ammunition to be able to go back where there are unreasonable requests to raise certain things back to the person making the request. Next slide, please. Complaints. Certainly, I've just talked about complaints and the fact that there is a requirement with DSARs that if there is a complaint about the DSAR, then initially it will have to go to the organisation receiving the DSAR. The ICO has also pushed for, and it's found its way into the legislation, that organisations are required to have a complaints procedure relating to personal data and how they handle personal data issues. And the reason for that is the ICO in financial year 24-25 got around 43,000 complaints because people just run to the ICO. So it is positive in one way, but obviously it does mean that you will need to put together a complaints procedure dealing with data complaints, and you'll see from the slide that all complaints have to be acknowledged within 30 days and you have to move complaints on. It is also possible, as you'll see from the slide, that you may have to notify complaints in terms of that is something that is possible. And certainly that is the way the wind is blowing with data breaches, in that even if you notify a data breach, even if it's not turns out to be a data breach and it's not notifiable, there is a record kept by the ICO and it is now publicly available. Very, very briefly, moving on to the next slide with cookies. You may well know that with cookies, you can only drop essential cookies without consent. What the idea is under the Data Use and Access Act is that there will be some other cookies that can be dropped without consent. So, for example, you see from the slide where you're collecting statistical data. I think there's been a recognition in terms of there are some pretty low-level cookies that aren't that intrusive, and people find the preference centers and the cookie consents quite clunky in terms of user experience with websites. So there will be certain other cookies that can be dropped without consent. It's probably worth mentioning, though, that you still have to be transparent about those cookies. So your cookie policy still needs to mention them. So it is quite important that that's included. Very briefly on the next slide, that I think there's a recognition from a statutory point of view. It's primarily in relation to information society services, so online environment, that children have got higher rights from a data protection point of view. I mean, that should come as no surprise, and certainly the inclusion of that in the legislation is helpful. I think if you do deal with children and handle children's personal data, a recognition that children aren't so sophisticated in terms of understanding what they're consenting to, or things like that, mean that they have to get better protection around their personal data. A couple of enforcement actions that I thought it might be worth mentioning, because there are themes. So if we can move on to the next slide, and this is very, very much a canter through. There is a recognition that organisations in the charity sector do face particular challenges from a data protection point of view, which can lead to enforcement action, in that obviously in terms of there's quite often not a huge amount of money to spend on policies, procedures, training. The IT in smaller charities may not be as sophisticated as some other charities, and all of that can lead to issues. And I think there are some themes, and there were two enforcement actions very recently, and sort of these themes came out of it, in that, because also one of the other things I should have mentioned is that there's also a recognition that with volunteers not always being permanent staff, and having a lot of volunteers potentially does cause problems in terms of training and understanding what the policies and procedures are. And certainly moving on to the next slide, I'll briefly talk about two actions that the enforcement actions that the ICO have taken. One was in relation to essentially BirthLink, which handled the adoption contact register. So it had a lot of very personal information on it, were kept in hard copy. So things like handwritten letters from birth parents, photographs, things like that. There was so much documentation that it was being digitized, and some of it was being destroyed, and some of these documents, like handwritten letters, etc., were accidentally destroyed. I think there was generally a view that it was unclear within the organisation as to what could and couldn't be destroyed. There was a delay in notifying the ICO, that there weren't the sort of policies and procedures weren't ideal from that point of view. So there was a lack of understanding, as I say, and poor policies by volunteers and the people involved, poor training. So that ended up with obviously irreplaceable items being destroyed, so therefore the ICO fined. There was also a fine levied against the YMCA, moving on to the next slide, where essentially information went out to some people who were part of their positive health program, which was a health and fitness program for those living with HIV. The instruction given was to send out the information via BCC, notwithstanding the fact I think it was admitted that there was mailer software within the organisation, but they used BCC. As you can imagine, as it happens a lot, there was a mistake, and the email addresses of everyone they were contacting went into the CC field rather than the BCC field. And there were over 150 people who were contacted and could see who the other people were who were obviously living with HIV and part of the programme. And again, same sort of things in terms of, making sure that people were properly trained, that BCC shouldn't be used for these sort of things, and that the charity had the resources to have mailer software and they should have used those sort of things. So very quickly, as I say, the sorts of things that I was flagging in terms of the things that make it challenging from a charity point of view were essentially underpinned, some of the aspects of it underpinned these two enforcement actions. I'm not going to go through, because we are massively out of time now, the timetable for preparation, but you will get the slides and you'll see that what I've done is I've set out in terms of broadly what should you be doing now in terms of reviewing your data, etc. What should you be doing in the spring, short to medium term actions, and what should you be doing when everything comes in from the Data Use and Access Act. And hopefully that'll provide you with the information that you're going to need. A little bit of a sort of checklist as to the sort of things you're going to be doing. As I say, very quick canter through, as I was up against it from a time point of view. So if you do have any questions, do drop us a line in relation to it.
That's great, Joanne. Thanks very much for that. A lot to take in, definitely, for charities to take in and organisations. We've had one question from Lisa, who's asked, given that they can't use the new changes retrospectively, if a charity already has someone on their database who didn't proactively opt into email communications when they were last engaged with, if that person then engages with the charity again, i.e. they attend an event or they donate, can the charity then update their contact preferences to a soft opt-in?
That is a very good question. And logically, the answer would be if you've got new engagement and they've chosen not to consent in the past, but it's been some time and they've chosen to engage subsequently, the logical answer would be you could regard it as the charitable soft opt-in. I would suggest, before you rely on that and start contacting people, is there's guidance due out, and the ICO will have to be clear about things like that, because there isn't. I think that works logically. There is an argument if they've chosen not to consent, they've not consented rather than just failed to tick a box. They've chosen not to engage, which is a choice. But I think the more sensible approach is that if they do engage with you and they donate in the future, that it would be available to you. But as I say, I think it's a bit of watch this space. We need to see the guidance. As I say, it's typical with data protection issues is that there's a bold statement, but then the devil's in the detail with the ICO guidance, and we're waiting for the guidance. So should be due any time, fingers crossed.
Okay, that's great. Thanks so much, Joanne. That's brilliant. So just finally, just to bring the webinar to an end, I'd like to extend my sincere thanks to all of our Owen Mitchell speakers, Steph, Georgie, Danielle and Joanne, for generously sharing their time and expertise and explaining these quite complex topics. I've certainly learned a lot today. We hope you found the webinar informative and engaging, and many thanks for attending. We do appreciate your time A recording will be available on our YouTube channel shortly, and we'll share that link with you, as well as all of today's presentations that you can pass on to your colleagues as well. And all of our speakers' contact details will be in there as well if you'd like to ask any future questions. As a reminder, please do take a moment to complete the feedback form that we've published on the Q&A site. Your input's really invaluable to us as we plan future events, and we're also hoping to potentially put on a face-to-face charity conference next year. So we'd love to hear what topics you'd be most interested in exploring on that day. So thank you once again for joining us, and enjoy the rest of your day. Thank you.